Good afternoon. This is an oral argument on the petitions of OptionsXpress Incorporated and Jonathan I. Feldman and the Division of Enforcement for review of the initial decision of an administrative law judge. A total of 40 minutes has been allowed for the argument, with 20 minutes allocated to each side. Respondents will argue first and may reserve time for rebuttal. I understand that the respondents have agreed that they will divide their time and have 10 minutes each. And I guess, Mr. Senderowitz, on behalf of OptionsXpress, I guess first question is, do you wish to reserve time for rebuttal?
2 minutes.
Okay, very good. You may proceed. Thank you.
Chair White and Commissioner Stein and Commissioner Pivovar, first of all, thank you for giving me the opportunity to present today. My name is Stephen Senderowitz. I am from the Denton's Law Firm in Chicago, and I represent OptionsXpress. My co-counsel is Charles Klein, who's sitting at the podium at the table. He is from Winston & Strawn in Washington. And our client, Mark Tellini, the Deputy General Counsel of Charles Schwab, is here, and he's sitting in the second row. Charles Schwab, I think you all know, owns OptionsXpress. This case focuses, as the commissioners are aware, on Rule 204, which is a strict liability rule that governs how to cover short positions that are created in a customer's account after the account receives an options assignment. In this case, OptionsXpress's customer, Jonathan Feldman, traded a self-directed, hedged option strategy in his account in 2009 and 2010. Part of that strategy involved writing deep in the money calls, and those calls were frequently assigned. Rule 204 requires that when an assignment is received and a resulting short position is created in the customer's account, that the broker-dealer, in this case OptionsXpress, forces a buy-in of stock of like kind and quantity to cover that short. The buy-in is required to be done by the morning of the fourth day after receiving the notice of assignment. While CNS issues a notice of the buy-in, the proof of the buy-in is not done by what is shown in the CNS system. Rather, under Rule 204, the buy-in requirement is completed when the buy is reflected on the books and the records of the broker-dealer, in this case, OptionsXpress. Now, the proof at trial from our back office personnel, from our executives, from our expert, established that every time Mr. Feldman's account received an assignment that created a short position, every single time, OptionsXpress timely, within the time required, forced a buy-in, covered the short position, reflected that on our books and records immediately, and reported the information to the clearinghouse on every single occasion. That should have ended the inquiry. However, the OIP, the order that instituted proceedings, alleged that the buy right was a sham closeout. It alleged that OptionsXpress allowed Mr. Feldman to attach the writing of a new call to the buy-in as part of a transaction commonly known as a buy right. The OIP further alleged that because the new call was often but not always assigned within a day or two, creating a new short position, that in effect the short position was continuous and was never truly closed out. Now, there are several reasons that this whole theory is wrong, as demonstrated by the proof at trial. First, Rule 204 defines what a sham closeout is in 204F. And as the trial went on, the staff and eventually the court acknowledged that we did not violate 204F. Having conceded at trial that we did not violate 204F, the staff now contends in its briefs that what this buy right represented was a wash trade. Now, first of all, the OIP does not charge wash trading. Second, unlike a wash sale, all of the buy rights here had an economic purpose. For OptionsXpress, the bona fide buy-in covered the option assignment and was immediately reflected on our books and records, satisfying our reg show obligation. The evidence showed that as to Mr. Feldman, he decided to write a new call attached to the buy-in as part of the buy right to reestablish his hedge and to lower his transaction costs. Third, Mr. Feldman just wrote an option, which at the end of the day may or may not have been assigned. He did not sell short, he did not sell stock. Writing a new call is different transaction. It's a different transaction, and it doesn't negate a stock purchase. Fourth and finally on this point, the fact that two distinct trades were combined for execution purposes is irrelevant, and it's certainly not a sham. For example, CNS records would have looked the same had OptionsXpress purchased stock to close out the short position in the morning, and some customer other than Feldman happened to write a corresponding call later that day. In sum, Commissioners, the division argues that some buy rights, depending on whether the call is deep in the money and depending how persistent they are used, can violate Rule 204. However, this, quote, "I know it when I see it" standard, or as Judge Murray called it, if it looks like a duck, walks like a duck, and talks like a duck, it doesn't provide any guidance to the industry, and it can't be the standard for imposing liability under a strict liability rule. And that's precisely why Schwab has contested this case. I'll briefly talk about fraud. Not that we're charged as a primary violator, we're charged as an aider and abetter. And the division concedes that the case of SEC versus Howard controls, which requires that we must have acted with extreme recklessness. The Howard case holds that to be liable as an aider and abetter, we had to have acted with at least extreme recklessness in aiding that strategy, yet nothing was further from the truth in this case. The division will tell you that after the Hazon and TJM market maker flex option cases came out in the summer of 2009, that OptionsXpress employees in the compliance and back office departments who read them raised questions about the trading in Mr. Feldman's account and whether or not those cases indicated that something might be wrong. But what happened next is key. They sought advice from the internal executives and legal counsel at OX, OptionsXpress, and they also sought guidance from their regulators. They had interaction with the CBOE, FINRA, and the SEC. And most importantly, the CBOE, which is, does that mean I have 1 minute left? Okay. Most importantly, thank you, Chair. Most importantly, the CBOE, the principal SRO for my client, did an investigation of the buy right trading, and in September of 2009, closed out the investigation after talking to trading in markets and determined that there was no violation of Reg Show. Now, under Howard, this green flag from the CBOE defeats any finding that we acted with extreme recklessness. Howard holds that aiding and abetting cannot rest on the proposition that a person should have known he was assisting violations of the securities laws. It's much more than should have known. Further, even though the SEC, FINRA, and CBOE were all aware contemporaneously of this trading as it was going on through conversations with us and each other, at no time did they tell us to keep Mr. Feldman from trading until March of 2010, and that's when we closed it down. Thank you.
Thank you very much. Mr. Lawrence, on behalf of Mr. Feldman, I guess first, do you wish to reserve time for rebuttal?
Yes, Chair White. I reserve 3 minutes for my rebuttal.
Okay, very good. You may proceed. Thank you.
Good afternoon. My name is Greg Lawrence, as you said, Chair White. Commissioner Stein, Commissioner Pivovar. I'm here with my co-counsel, Hannah Kahn. You can't see her. I'm sorry. Hannah, move out a little bit.
We see you.
And my client, Jonathan Feldman. Now, Jonathan Feldman's trades aren't the only trades at issue here. He's one of several clients who engage in this strategy. And the Reg Show case that you're here to decide presents complex and interesting questions and indeed credibility assessments of witnesses. The fraud case against Mr. Feldman, however, presents no interesting questions. It's unjust and it's without merit, and that's for two primary reasons. First, OptionsXpress, as Mr. Senderwich just told you, consulted with the SEC, and after that consultation, they told Mr. Feldman specifically that the SEC had looked at his trading strategy and approved it, and looked at OptionsXpress's compliance with their delivery obligations and approved it. That's uncontested. Second, the initial decision adopts an unjust and radical definition of what delivery means for a customer. The customer is not relied upon delivery, a retail customer isn't relied upon delivery in most instances, including in this case. And it's uncontested OptionsXpress assumed all the obligations for delivery here. Mr. Feldman's only obligation was under his contract with OptionsXpress. And it's uncontested, and Judge Murray found that Mr. Feldman complied with every request made by OptionsXpress, and that he was truthful and honest with everyone with whom he dealt. Everyone. That's uncontested. He needs to be treated completely separately from OptionsXpress in this case, because the OptionsXpress case really is about reg show. Mr. Feldman doesn't work for a broker-dealer. He doesn't have any securities license. He's not a compliance professional, to be sure. I don't say this to try to convince you that he's not intelligent. He's very intelligent. But he learned about reg show for the first time in the middle of this trading. He learned about how trades are affected and regulations show. This was in August of 2009, after the period that they're already charging him with fraud. And then later, a month later, he learns of an issue with Hazan, right? He's provided a copy of Hazan, and immediately he gives the astute observation that his trading is completely different than that was addressed in Hazan. He was entering open market trades on standard options to unknown counterparties, and he was complying with every delivery obligation of his broker-dealer. He was engaging no deception whatsoever, and in fact, he did not want to be assigned, because when he got assigned, that affected his strategy. 4 days after learning of Hazan and any potential issue with his trading and delivery obligations, he's given the express confirmation from Peter Bettini, the executive vice president of one of the largest trading firms in the country, in the world, that they had consulted with your staff and concluded that his trading strategy was appropriate and they were satisfying all their delivery obligations that resulted from it. 2 days after that, Mr. Feldman is told in the phone call the same information, so he gets reconfirmation. He believed them. He believed that the SEC had actually approved of his trading strategy and that OptionsXpress was fully complying with his reg show obligation. Was that true? For this fraud case, it doesn't matter. It doesn't matter at all. They said it, they never took it back, and they confirmed to him over and over and over again after that they were taking all their delivery obligations and conforming them. Now, the initial decision says that, well, actually, and let me back up for a second. The initial decision almost doesn't even address the SEC approval. The initial decision and the division talk about how Mr. Feldman can't rely upon OptionsXpress for two reasons. Number one, they're making money off his trading. Well, that's every situation for a broker. Number two, he's sophisticated himself. Well, that overstates it, and I've already addressed. He's not a compliance professional. He's just learning about the rules, and the rules are very sophisticated. The initial decision naively suggests that he should have called the SEC, and yet the SEC representative who testified said they would not have even taken his phone call. SIBO testified to the same thing. FINRA testified to the same thing. He couldn't get guidance if he wanted to. In any event, even if he fully understood reg show, he didn't have the tools and the visibility to actually determine whether OptionsXpress was complying with it. Why? Because you need the books and records of the broker-dealer, and you need the CNS position. He had neither. Ultimately, he did consult with an expert in reg show, and that's Dr. Eric Seary. Dr. Seary was the director of trading markets, as the chair and commissioners know, was the director of trading and markets for the commission. And he confirmed that Mr. Feldman's trading would not have caused OptionsXpress to violate reg show. I repeat, would not have. And he was the director of trading markets when Rule 204 was passed, when Rule 10b-21 was passed. Dr. Seary's analysis was even more enlightening, though. He looked at all the trading that Mr. Feldman engaged in. And so he looked at it in toto, and I've got the screen up on the slide up on the screen here. And in fact, it shows that the division and the initial decision are relying on selective data to show that there was a high frequency of assignment of his calls on the same day. In fact, there wasn't. It was variable. And so the initial decision actually takes off just little slips and slaps of the actual trading strategy. Only about 30% of it is charged. And the initial decision, and please don't make the same mistake, the initial decision says, well, that's just trading that he engaged in the strategies without using buy rights. That's not true. As Dr. Siri's slide shows, the white dots there, the white dots show actual buy rights being used. And by the way, all those positions, all of them weren't charged. There's also a bar graph that shows that the same-day assignments were actually less frequent. As a final point, the disgorgement figure used was unacceptable and violated his due process rights. Rule 600A requires the commission to find each violation and calculate disgorgement. She threw up her hands and said, I'm not going to comply with 600A because there's too much trading here, and I'm just going to use rough estimates based on faulty data. Dodd-Frank gave this commission broad power over lay people. Lay people deserve the same due process and justice that they would get in a federal court, especially when you're alleging fraud against them. Here, this hasn't happened yet. And it hasn't happened because the division hasn't responded to, and the initial decision doesn't address very fundamental arguments that we've made. They just ignore them when we talk about in the reply brief. But today, let me give the division one last chance. Under these facts and circumstances, how can Mr. Feldman be held to be making a misrepresentation when the Commission's own adopting release for 10b-21 says that a customer would not be making a representation if they're relying on their broker for compliance? Thank you.
Thank you very much. Mr. Block, you may proceed.
Chair White, Commissioner Stein, Commissioner Pivovar. This case, despite its complexities, really boils down to an old-fashioned deceptive securities trading scheme orchestrated by Mr. Feldman with the assistance of OptionsXpress. When the Commission passed Rules 204 and 204T, it was in an attempt to address failures to deliver at CNS. And as the CNS records show in this case, we had a tremendous amount of failures to deliver by OptionsXpress. Clearing firms are required to deliver shares to CNS by T+3 after there's been a short sale, trading day plus 3 days. If they do not do so, they will have a failure to deliver at CNS. And on T+4, the very next day, they, per the plain language of the rule, are supposed to close out that failure to deliver position by purchasing or borrowing securities of like kind and quality in a bona fide transaction. As Judge Murray found in her initial decision, the deep in the money calls that were part of the buy rights were essentially a short sale because there was almost a virtual certainty of assignment of that deep in the money call. Therefore, it results in a short sale, and neither Mr. Feldman nor OptionsXpress had any intention of covering that short sale. By allowing customers to execute buy right transactions in hard-to-borrow securities with deep-in-the-money calls, OptionsXpress allowed Mr. Feldman and the other customers to engage in an abusive naked short-selling scheme. Many abusive naked short-selling schemes are like this one. They're not designed to drive down the price of the security at issue. Instead, as the Commission realized and spoke of in the adopting release on page 2 back in 2009, they're designed by individuals seeking to avoid paying hard-to-borrow fees. That's what happened here. It costs money to borrow a hard-to-borrow security. If you do not pay that money, you are getting something for free, the stock borrow, when everybody else in the marketplace isn't. Everybody else who shorts the stock has to pay that hard-to-borrow fee.
Mr. Block, can I interrupt you for just a second and focusing on your theory on Mr. Feldman? I mean, there's no contention, I take it, that Reg Show applies to a retail customer. You're not contending that?
Never have.
Okay. And did Mr. Feldman have, in your view, any obligation under the securities laws to deliver securities to those on the other side of his transactions?
So there, yes, absolutely. Now, I think...
Explain that to me.
Okay, so Mr. Feldman's point is he has no ability to deliver shares into the CNS system. That's a clearing firm responsibility. That's absolutely true. We've always agreed with that. But he's got an obligation to live by the terms of each one of his trades. And that's what the Supreme Court said in the Worf Holdings case on an options contract. If you enter into an option contract with a secret intent not to fulfill each one of its terms, you're committing a fraud. And that's what he did. He did not intend to ever make delivery on there when this options assignment takes place, because that would ruin all the profit in his transaction.
But wasn't Mr. Feldman pretty open about his strategy? And I guess before you answer that question, let me give you another one if I could, and that is, do you contest that Mr. Feldman was assured by OptionsXpress personnel that the SEC was fine with his strategy?
So the second one, taking that one first, if I may, that's his testimony that somebody at OptionsXpress told him that. It's not, he didn't bother to call the individual from OptionsXpress to corroborate it. So that's what the record is right now. It doesn't add up with anything else in the case because there's no other testimony that anybody at the SEC ever approved Mr. Feldman's trading strategy. So Judge Murray's point, which is the right one, which is that's the one representation he's going to take as true in this case. Is that really reasonable? OptionsXpress is making millions of dollars in commissions off of it. He knows that, yet he chooses to take this one representation that suits his purposes and go forward. Moreover, 1 month later, he switches to go to another broker-dealer and try this strategy. About a week in, they immediately shut it down and tell him they're going to charge him hard-to-borrow fees. He disputes whether he owes them. But the bottom line is, after this alleged representation happened, he goes right out there, tries it again at a different firm, gets it shut down. That's, again, another red flag. Moving forward, he's also told by an individual at that broker firm that CBOE is very heavy on this activity. Regulators are skittish about it. He comes back to OptionsXpress. What do? They increase the size of his commissions, telling him that it's because they're still having to deal with regulators about the trading. So is that belief really reasonable? That's what you have to ask yourselves as you're considering the facts. This one phone representation, he didn't get the details of it. They put the slide up. His recollection of it is completely vague. So the short answer is to your question, that's the state of the record, and what you need to consider is whether that belief's reasonable. And the last thing I'd say about that is, why in January of 2010, if he thought the trading had been cleared by the SEC, would he joke with his friend and send an email to his friend that says, oh, this is great. Look, they are totally confused by our trading. It's all fun and games until somebody notifies the SEC and shuts the strategy down. People don't make that kind of joke if they think it's been cleared previously. As Judge Murray found, he never bothered to consult with outside counsel and find out the legality of this. And he's not the kind of guy who takes no for an answer, because after OptionsXpress shut it down, what did he do? Went to E-Trade first. They shut it down. Did he take no for an answer then? No. Moves on to TD Ameritrade. And then they kick him out for doing the same trading. So his belief, as you're weighing through the evidence, I think you can ask yourself whether it's truly reasonable. And backing all the way up to June 2009, before he even engages in this, he's on a message board talking about the trading, and somebody puts him on notice. It's like, how's that going to work? If you get assigned, you're going to get bought in by your clearing firm. He claims he never saw that, but it shows you that all you have to find is at a minimum he was reckless. And if you decide he's not reckless, you still have to consider whether he was negligent in engaging in this type of conduct. And I forget what your first question was.
I think you answered it in the course of that, so that's fine.
If I can turn back to the arguments raised by Mr. Sendowitz on behalf of OptionsXpress, and that is he claims a literal application of Rule 204 somehow allows this conduct to take place. But that just ignores the plain language of Rule 204 because it requires an immediate closeout of the failure to deliver position. If there's no delivery of shares to CNS, you're not making a closeout. That's why OptionsXpress had a failure to deliver in Sears for over 200 days. It's because the buy and the right cancel each other out. There is not going to be any delivery taking place. Besides ignoring the plain language, it also ignores all the regulatory guidance that existed in the industry at the time. Guidance from Amex, guidance from CBOE, guidance from the Commission itself. For instance, in August 2007, Amex brought a case called the Ehrenstein case. And in that case, it was conduct very similar to what we have here. And Amex found that that violated Reg Show, Rule 203 of Reg Show, but still has a closeout provision. Amex in Division Exhibit 384 puts out a circular that talks about all kinds of other conduct that may be an improper closeout under Reg Show. And there was also buy rights used in that case, so take a look at it. And here's what the guidance said to the industry. The use of a buy right with a one-day deep-in-the-money flexed option to nominally close out a failed-to-deliver position and then shortly thereafter reestablish or reset the failed-to-deliver position is not the only means by which an age fail can be reset. Other transactions that can result in improper reset of an age fail include but are not limited to married puts, buy rights, or other delta-neutral short-term strategies matching options with stock. Mr. Feldman's admitted that's what he was trying to do, a delta-neutral strategy. Here, OptionsXpress is on notice in August of 2007 that that's not going to be a proper closeout of a Reg Show failure to deliver. They ignore it. CBOE also put out similar guidance. And this guidance that CBOE put out and Amex put out didn't say that the only way you can violate the closeout provision is a sham closeout under what's now in Rule 204F, which is a true arrangement between two parties. It doesn't indicate anything like that. CBOE said pairing the closeout with one or more short-term options positions that are utilized to reverse the closeout are deemed improper reset arrangements that do not satisfy the Reg Show closeout requirement. That's what we have here. This was short-term option because they were being assigned on an almost daily basis. Finally, when the commission at the time adopted Rule 204, they put in an important footnote, footnote 82, that talked about the concept you need a bona fide transaction in order to have a proper closeout. That means that transaction's got to have a legitimate economic purpose. And the buy rights in this case, the only purpose of them is to extend the fail to deliver position. Because if they're bought in, no profit. If they pay the borrow fees, no profit. So what the footnote's talking about is you need to engage in something outside of extending the failure to deliver position. Simply put, OptionsXpress's argument does not mesh with the plain language of the rule, nor does it mesh with the regulatory guidance that was out there at the time. Now, OptionsXpress also claims that their due process rights are violated. I just want to say quickly on that, we put it in our brief, the United States v. K case that says, this is from the Fifth Circuit, those who go perilously close to a line are not allowed to complain that they ended up crossing that line. And that's what we have here. OptionsXpress not only went perilously close to the line, they went well over it, so there really shouldn't be any due process defense here. Now, I want to turn to Mr. Sendewitz's argument that OptionsXpress did not aid and abet Mr. Feldman's fraud. And he relied again on the Howard case. But the Howard case is nothing like we have here. That was a case by the D.C. Circuit. In Howard, there were no red flags at all. The individual who was found not to have aided and abetted a fraud. Consider what we have here. Red flag number one, plain language of the rule. Red flag number two, all the industry guidance I just discussed, plus the other industry guidance that we cited in our brief. Red flag number three, their own compliance officer told their traders that they could absolutely not process the buy rights. They ignore that. Red flag number four, one of their junior traders who knows the most about the buy rights and places them, when he reads about the Hazan case, he sees the key passage and he has the absolute right reaction. I'm not placing any trades today. That's what he knows. He tells everybody. What do? They tell him to keep placing the trades and they move on with all these red flags. And as Judge Murray found, the distinctions they're trying to draw between the Hazan and TJM and the Ehrenstein case are totally unavailing because the purpose in those cases was the exact purpose here, and that's to avoid making delivery of the securities. Now, OptionsXpress, I think I heard him today say that they were proactive in reaching out to regulators. Take a look at the record, because that's not what it is. They were under investigation from CBOE and FINRA for this activity, so they didn't reach out to them. They were under investigation by them. And there's a difference of opinion about what happened between these calls and trading in markets and CBOE. That's for you to judge. But at bottom, what we have here is not a single regulator telling them that what they were doing complied with Rule 204. And what they want you to do is say that it's the regulator's job to tell them to stop. But that's not the law, as the cases we cited on page 47 of our brief point out. It's a regulated entity's job to make sure they are complying at all times with the securities laws. Indeed, Trading and Markets in September 2009 told them their customers may be engaging in a fraud or a sham transaction, but they let it continue. FINRA told them they had it under investigation the entire time. And what the testimony from even the individuals at CBOE that they rely on was like, they've never seen trading like this at all. CBOE wanted to bring a case, but unfortunately there was a miscommunication between CBOE and Trading and Markets, and you've seen the record on it. But at bottom, nobody cleared this trading in any sense of the word. So this case is not like Howard. When you look at the Howard case and compare no red flags versus all the red flags we have here, this case is more like the Graham case in the D.C. Circuit. In that case, the gentleman was found to have aided and abetted a fraud when he encountered numerous red flags. There were all kinds of trading irregularities, and he didn't follow up. And the D.C. Circuit said that's aiding and abetting fraud. Notably, the same defense about regulators appears in the Graham case, because in that case, the defendant tried to claim, well, an NASD examiner looked at it, and NASD didn't bring a case because the person at NASD testified he understood from somebody at the SEC that didn't violate the law. D.C. Circuit wasn't bothered by that, and the gentleman's found liable for aiding and abetting fraud. It's the same set of facts we have here. Now, before I turn back to Mr. Feldman, I just want to briefly touch on the disgorgement number for OptionsXpress, because this is where we differ with Judge Murray, and you have the power to de novo review the disgorgement number. We think you should order OptionsXpress to pay over $7.2 million in disgorgement. That's the amount of money they avoided paying in hard-to-borrow fees. Judge Murray gave us the commissions they earned off the buy rights, but the higher number is better deterrence, and it also matches the harm here, which is they were stealing this opportunity, the hard-to-borrow, from the marketplace and taking it for themselves. Now, they want to say they didn't have to pay to borrow, they could have purchased. Well, that's true, but they didn't purchase, they only did the buy rights. So the hard-to-borrow more fits what happened here than the commissions. Now, turning to Mr. Feldman, I want to just make a statement. He claimed, or sort of seemed to me to leave the impression with you, that he had consulted with Dr. Siri at the time he was placing this trade. If that's the impression you got, that's totally untrue. Be clear, Dr. Siri was his paid expert that he retained after we had already initiated litigation, or were in the process of initiating litigation against him. And we pointed out in our brief all the problem with Dr. Siri's opinions about Reg Show, and at the end of the day, Dr. Siri said he didn't even have enough information to determine whether Reg Show was violated or not. So it's not nearly as clean as Mr. Feldman's counsel would like you to believe. Now, to the fraud claim against Mr. Feldman, he's been found liable for 10B fraud in 10B-21. And I want to go back to some general principles of Section 10B, and that is it needs to be interpreted broadly and flexibly to take into account all the new cunning or manipulative devices that fraudsters come up with. That's what the Supreme Court said in the Ernst & Ernst case. And I submit to you that's what we have here. The buy right and the use of it here was just a new cunning or manipulative device. Now, it's true, buy rights are a regular tool that can be used in the industry. We've never disputed that. But their use here is what was illegal because it was extending the delivery obligations. He was never going to make delivery until his options expired, so he's stealing an opportunity for himself that other individuals do not get. And the Supreme Court has said just because something's legal for one purpose doesn't make it legal for all other purposes. And that's the Bankers and Life case in 1971 that said broad discretionary powers in the regulatory agency in these cases have been found practically essential. So we touched a little bit about Mr. Feldman's scienter, and I'd submit to you the case Pentagon Capital is quite similar to what we have here. That was a late trading scheme, and the defense was essentially what Mr. Feldman's is, which is my broker let me do it. And in response to your question, Chair White, I responded to why we do not think that belief was reasonable in the least. Mr. Feldman is not the type of guy who's going to take no for an answer. He found the weak link in the system, and he exploited it for his benefit.
Mr. Bullock, and I think this may have been my first question, and you and I both forgot for a moment there, but wasn't Mr. Feldman quite open, though, about what his strategy was?
So here's the thing. He was open with OptionsXpress. That's why we brought the case against them. But he wasn't open with the marketplace, as we pointed out. He didn't respond to the web page where somebody asked him about this.
But he had the web page, right?
What's that?
But he had the web page. I mean, he did.
He started the initial post. So he said what the strategy was, but not the entire strategy, because he did not explain, oh, by the way, I found this one broker-dealer lets me do the buy rights. That's what he left
And
empty.
just one more, I think. I think you made an allusion to, obviously this is a market manipulation claim. You laid out the evidence of C-enter that you're relying on. You also mentioned negligence. I mean, is there any case that you can cite to where actually the commission has brought a negligence-based market manipulation case?
I haven't, not off the top of my head. We could certainly submit something if we, just because Judge Murray had found C-enter, that's what we're up here on. So I have not done that research. And I can't remember what our brief below said, so if we found it, it would have probably been in there. Let me just...
I have a follow-up to that. Is there evidence in the record that demonstrates Mr. Feldman knew of the fails to deliver by OptionsXpress, or that he was on constructive notice of fails to deliver, or of a relationship of the fails to deliver and the buy rights that he was executing in the hard-to-borrow securities?
I think the answer to all three of those is yes. The reason he was told that he needed to at least do the buy right is because they had a failure to deliver at CNS, and that he needed to be bought in every day. And so, yes, and they passed him the Hazan case that talks about Rule 204 and the clearing agencies. Now, I think Mr. Lawrence's point is he didn't have access to their CNS records. That's true, but the reason they're telling him they're quote-unquote buying him in and him doing the buy right is because they have failures to deliver.
So a follow-up to that is, why should the commission hold Mr. Feldman liable for the ineptitude of OptionsXpress, which failed in its delivery obligations? If we did not hold Mr. Feldman liable, what behavior then would we risk sanctioning? So it's two sides of the same.
So I think the behavior risk and sanctioning is you're asking people to go out there and find the weak link in the system and take total advantage of it. He had enough knowledge to know that's what he'd found here in OptionsXpress. No other firm let him do this for any period of time more than a month or so. OptionsXpress let him do it for months on end in huge volumes. Just take a look at the Sears one itself.
Any other questions? Thank you very much. Mr. Senderowitz, your rebuttal?
The transcript in this case is 5,000 pages long. The briefs attempt to distill those transcripts, and the arguments today attempt to distill them even further because of the time allowed. I have 2 minutes left, probably now about 1 minute and 45 seconds. So I'm going to go through a bunch of points very quickly. I do urge you to read the briefs. Commissioner Stein, I don't know if you were directing the ineptitude comment towards my client about our closeouts and whether it was inept. It wasn't inept. The testimony in the record, the facts of this case, by the testimony by that we reference at our brief at 17 and 29, our reply brief at our briefs at 17, 29, 46, 47, the Tortorella testimony from 452 to 495, our back office guy, all says that we bought in with the buy right. And that buy-in was recorded on our books and records, and that information went to the clearinghouse every single time. Whatever they say, they can't disregard the fact that we did that every single time. Even their expert, Mr. Harris, agreed to that. When I asked him why his figures were so off, he said, well, I didn't count the buy rights. I said, why didn't you count those? Well, because I didn't count the buy rights as part as to whether you covered when I calculated this. I said, if you do count the buy rights, did we cover? He said, yes. You have to look at the record in this case.
I guess one of my questions is, even assuming the CNS summaries were viewed by the firm as inaccurate, during the periods in question, why weren't fails to deliver detectable from your own records?
Well, first of all, we get an assignment notice on day 1. A fail to deliver issues the evening of day 3. The fail to deliver notice is simply a notice that if you don't cover by the next morning, then you'll be in a fail to deliver situation. We always covered the next morning. CNS is a net settlement system at the broker level. It's not at the customer level. These were separate transactions. We bought in, he happened to tie a right into it, but that right was alive and well. It lived on that day, the next day, and into the future. Sometimes it was called, sometimes it wasn't. It wasn't always called. It wasn't a virtual certainty, as Mr. Block said. Could I have 15 more seconds?
Surely, go ahead.
Or 30 more seconds?
You give 15 and...
I'm sorry, Chair White. Very quickly, the testimony was that other brokers didn't charge hard-to-borrow fees. We weren't charged with any wrongdoing by not charging hard-to-borrow fees. The markets were not adversely affected. Their own experts said prices weren't affected. There wasn't one customer who was owed a delivery that testified and said he didn't get it. There was no evidence. There was no evidence. If these buy-ins weren't right and they didn't happen, why weren't their customers testifying in their case, hey, we didn't get our delivery? Because they all did, and that's what the record shows. The cases they cite all involve 204F violations and prearrangements. The one buy right case they mentioned was a buy right that was written the day before expiry. That's not the situation we had here. This is what I'm saying. When you have staff get up here and tell you certain things, you have to look at the briefs to see what the real facts are here. And so that you understand, as I was able to explain to you in that little snippet about how the process works, how we really did cover here. We covered every single day. We did everything we were required to do, Commissioner Stein. We weren't inept at all. And just...
Thank you very much.
Thank you very much.
Thank you very much. Mr. Lawrence, rebuttal?
Thank you. Well, the division had their last chance, and they still didn't give you an answer. And that is 10B21 adopted and released said a customer doesn't make a representation. And that's expressly what this case is based on, the initial decision and the entire case of the division. Instead, they cite Wharf Holdings as giving an example of why this is fraud. Because when you sell an option, you have to live up to it. And if you sell an option without the intent to deliver, then that's fraud. Well, Wharf Holdings didn't have the CNS system in place, which is exceedingly complex, but it makes your broker the one who's going to do all the delivery requirements after the option is sold. Wharf Holding is a simplistic analysis. Counterparties to a trade, face-to-face, physical delivery of whatever it is. It doesn't deal with what Reg Show deals with. It doesn't deal with the reality of this case and what the Commission has put in place and sanctioned with regards to how trades are settled. This is a Reg Show case, not a fraud case. Interesting questions. But here also I see people conflating the red flags potentially that were going on in OptionsXpress with red flags that would be for Feldman, just like they're conflating delivery obligations. Mr. Feldman was told that the SEC approved of the trading strategy and approved of the settlement of those trades. He was told nothing else. And so everything else after that, until he's presented with something that would be sufficient to raise an issue, is meaningless for him, for the fraud case. This is a fraud case against a layperson who's relying on their broker-dealer, and reasonably so. We believe they were complying. Dr. Siri did say that his trading would not have caused it. So if he was the only trader at OptionsXpress, then the trading would not create a CNS, would not create a violation of Reg Show. And to your point, Commissioner Stein, he was aware of CNS fails because they told him. It started at about the time with Hazan. He started learning about why they were requiring him to take certain actions because they had to comply with Reg Show. So they started implementing new restrictions on his trading, right? They were telling him we have to do things differently because certain things are happening. The other brokers didn't tell Mr. Feldman that his trading was violating Reg Show. That's just false. That's not the testimony. There are capital requirements that are caused because of his trading such high volume and the massive positions that he was putting up. We don't dispute that. He was perfectly comfortable with it. He was taking the risk with those positions, but the brokers were incurring charges. OptionsXpress, however, did not pass along hard-to-borrow fees. Either did E-Trade, either did Pinson, either did TD Ameritrade. That's how he made money. He made money off of doing his trades with brokers who didn't charge hard-to-borrow fees, because a lot of times he actually just sold the security short for a hard-to-borrow stock, and they didn't charge him the hard-to-borrow fee, hard-to-charge fee. In any event, I'm sorry, Commissioner. So he made money legitimately at all times. Certainly in his mind, he had identified an arbitrage opportunity. He deserves justice here for these fraud charges. He's a layperson who is relying on his brokers reasonably. Thank you very much.
Thank you. Any other questions? All right. We appreciate your participation in the arguments. The commission will take the matter under advisement. We stand adjourned.